Hi there, this is Jonathan Ginsberg, and today I'd like to talk to you about the role of the vocational witness in a Social Security disability hearing. Now, you may find it a little bit odd when you go to your hearing. When you walk in there, there's a pretty good chance that besides the judge and your attorney and the judge's hearing assistant, there's going to be somebody there you've never seen before. And this is a person who's going to be a witness in your case. And that person is called a vocational expert witness. And the most important thing to remember about the vocational witness is that they are not there to help you or hurt you. They're just there to answer questions from the judge. Because remember, the main issue in a Social Security case is whether or not there's any kind of work you can do, any kind of substantial work you can do. And the vocational witness's job is to identify what you've done in the past, tell the judge if you have any skills that would have naturally arisen from that job, and to answer questions from the judge about what you might be able to do given the limitations that the judge finds. Again, the judge is going to evaluate the medical evidence and try to make some conclusions about your capacity for work, what is called your functional capacity for work. Then the judge will turn to the vocational witness and say, I'm going to give you a hypothetical. And of course he's talking about you, but he's going to say, I'm going to give you a hypothetical. Assume we have an individual who's the same age, has the same education and work background as our claimant, and further I find this individual is limited to light work or medium work or sedentary work with the following limitations. And the judge will identify a variety of limitations. And obviously the more limitations, the better. Based on these limitations, and again, they could be this person cannot do overhead reaching with their right upper extremity, or this person cannot lift more than 10 pounds except very occasionally, or this person cannot climb ladders, ropes, or scaffolds. Whatever those limitations are, that'll be put into the hypothetical, and then Mr. Vocational Witness, based on this hypothetical, can our hypothetical person return to past work? And if the answer is no, then you've passed what is called step 4 of the sequential evaluation process. The next question, are there any jobs this person could do? And if the answer to that question is no, then you've won. So again, what you want to do is you want to have as many limitations as possible into that judge's hypothetical. And the way you do that is you basically testify, and your testimony needs to have a lot of limitations in it. So when I'm when I'm doing a direct examination of my client, what I'm going to do is I'm going to ask you, to tell me how much you can lift, how far you can walk. Do you have any trouble with your right arm, with your left arm, pushing, pulling, those type of things? And the point of it is to draw out from my client, from you, as many limitations as possible in your testimony, because what I find is that many judges will take the limitations directly from testimony and incorporate that into the vocational witness hypothetical. Not necessarily that's not going to be the only hypothetical they ask, but you want to make sure that at least on its face you've presented to the judge, we've presented to the judge enough limitations where the answer to the hypothetical question is, Your Honor, I can't see any jobs this person can do. Now, obviously, if the medical record contains additional limitations in the form of a functional capacity form or other records, that's even better. But you want to make sure at a minimum that your testimony identifies as many limitations as possible so that the hypothetical question on its face gets the answer, there are no jobs this person can do. So that is what the vocational witness does. The vocational witness is going to use, by the way, a book called the Dictionary of Occupational Titles. This is a Department of Labor publication that identifies the mental and physical demands for every job and also the exertional demands for every job. And so the vocational witness will classify your jobs using that title, the Dictionary of Occupational Titles. You can go look that up on the internet if you want to see what it looks like. But again, the most important thing to remember is what you're really trying to do is prove that even a simple entry-level unskilled job, I call it a warm body job, that you could not do that because of the limitations. And typically the limitations I focus on are going to be reliability problems. Need to take unscheduled breaks to go to the bathroom, need to take unscheduled breaks because of mental or physical problems, that you'd be likely to miss too many days from work. These are all reliability issues, and that really goes to the core of your capacity to perform even a simple entry-level type of job. So that is what a vocational witness is there to do. The vocational witness in most cases testify about your capacity, and again, our job, you as the claimant, me as the attorney, is to identify as many limitations as possible that will hopefully make their way into the judge's hypothetical question, so that the answer that the vocational witness gives to the judge is, Your Honor, there are no jobs that I can think of that this person could do. That's what we want. That's what we want to get. If that happens, we win. So that's information about the vocational witness. This again is Jonathan Ginsberg. I hope this has been helpful, and please contact me if you have any questions or want a free case evaluation. Thank you very much.